Hey Cyberclass, it's Professor Opterbeck, and I'm making this short video to discuss the Elonis and Counterman cases, which were in our reading for this week. And these cases are both really important for our discussion of stalking and threatening speech, what we're calling part of personal security online. And as we've been exploring this week already a little bit, this question of personal security online is a really sensitive one, is a really difficult one, and a really important one. We've talked a bit about the scale of economic crime online, but in many ways the scale of the problem of harassment and stalking and bullying and things of that sort online is probably quantitatively even bigger, maybe qualitatively as well, depending on how you're looking at kind of the difference between money and people's mental health and all sorts of things like that. But it's just another one of those ways, in my view at least, that the sort of rosy Barlow-esque view of the early internet as this place of, rough and tumble discourse, but kind of reasoned discourse that polices itself, really hasn't totally held. All right, so Elonis, 2015. And you can see the issue in Elonis is the federal statute that involves the transmission of threats. Now you should note that, these statutes about, both at the federal level and at state levels, I give you some New Jersey statutes to look at. These statutes about threats and statutes about stalking predate the internet. Now some of the statutes, as you read them, are updated to mention specifically kind of cyber stalking or cyber harassment, things like that. But, the concept certainly predates the internet. And so, many of the issues that we're talking about, and in particular with speech, with threats, and how that relates to the First Amendment, is also something that predates the internet. And, the court has long held that true threats, whatever true threats means, is not protected First Amendment speech. Now, to say something is not protected First Amendment speech is not to say that it's automatically unlawful. It's just to say that the government could put penalties on or criminalize that kind of speech without falling afoul of the First Amendment. So, of course, we do have these criminal statutes about threats and about stalking on the books. There has remained, however, an open question about mens rea. In other words, what knowledge, if any, does the defendant have to have in order for something to be considered the kind of true threat or the kind of thing that could be criminalized without falling afoul of the First Amendment? And that issue is, as a practical matter, these questions about stalking and threats and harassment, like so many other things, are just amplified many times over by the internet. Pre-internet days, you might send somebody faxes or send somebody letters in the mail. It's all basically analog. I mean, I guess faxes are digital, but you start with something, analog. Just the scale of the possibility of doing this and the ability to, connect with and reach somebody that you don't otherwise know and wouldn't otherwise have access to is also really vastly increased. So the questions have just become more urgent. In Elonis, we see an unfortunate pattern. So some of the cases that we see involve people that have known each other and have had a relationship, whether they were married or whether they were in a romantic relationship or a business relationship, or one party wanted to be in a relationship and the other didn't, right? Those kinds of situations are very common. Another set is, which we'll see in the Counterman case, is people who never knew each other at all. But here we've got, Elonis, their marriage falls apart. He starts posting stuff on Facebook. He loses his job, and then he starts posting some additional things. And you can see in the case how the things that he begins to post about his wife begin to escalate. This isn't, by the way, another pattern you often see in these cases. Often things start with what you might think of as maybe a little bit unpleasant, but sort of expressing annoyance or frustration or whatever, and then things escalate and they start to become suggestive of actual violence or other things like that. Now, Elonis has a unique defense here. He claims he's a budding rapper and his posts are emulating rap lyrics. Now, when we look at the facts of this case, that seems wildly implausible. This does not seem like a person who had any kind of serious budding rap career, and it seems pretty easy to call BS on the claim that these are just rap lyrics, even if he sort of frames them in terms of them being rap lyrics. Now, when we look at Counterman, I want you to put a marker on that for a minute, because in just a moment, when we look at Counterman, we'll see that the dissent is actually concerned that certain community, the dissent kind of uses this academic-y phrase, communities of discourse, right? Certain communities of discourse that have norms of speech that could be perceived by the majority community or by other communities as something that they're really not. And, I think part of what the dissent in Counterman is getting at is indeed genuine rap lyrics. And I don't know how many of you are rap fans. I enjoy rap. I really enjoy old school rap, like Tribe Called Quest and stuff like that. My one son is a big fan of rap and trap, and I gotta be honest, some of this stuff is just really hard to listen to for me, because it's not my community of discourse, and I perceive things in those lyrics, taking them at face value, that seem really violence, misogynistic, use of language that I wouldn't use, things like that. But that's a real concern. Now I think here the majority kind of brushes past it because it's just not that plausible, but we'll come back to it in that concern of the dissent in Counterman. All right, so, typical criminal case procedural history. There's an indictment. In criminal process, we're all learning about this in the news these days, even if you're not a criminal process person. Information gets presented in a typical case, or in many cases, to a grand jury. The grand jury is sort of an initial check on the prosecutor's discretion. It's just saying, yeah, there's enough evidence to go forward here with a case. An indictment issued, which is really the document formally charging the person with crimes, and then the defendant procedurally has the opportunity, if they choose to move to dismiss the indictment, similar to a motion to dismiss in a civil case, to argue that the indictment doesn't state a crime, or that the crime charged is under a statute that is unconstitutional as applied or on its face, or what it might be. So Elonis is making that motion, right? And then the case eventually goes to trial. Elonis is convicted, and based on the jury instruction, the case goes to the Supreme Court. So notice the jury instruction. The jury was instructed that the threat element of the statute is satisfied if a reasonable person would construe the statements as threats. So this is basically a negligence standard, right? Now Elonis is saying, "Hey, I'm just doing rap lyrics. I'm not seriously threatening to harm my ex-wife. I'm just, venting my feelings in rap lyrics." Not unlike if you listen to some contemporary trap song, and there's talk about gunplay and fighting rival rappers. They're not seriously thinking of shooting each other, right? That's just part of the discourse. So a reasonable person would have to say, actually, no, I really think I was threatened, and even if the person making the speech didn't actually intend that, right? So negligence is a fairly low standard of mens rea. And the court rejects, it says that jury instruction was not sufficient because of this question of what the mens rea needs to be. Now, within Elonis, there's some discussion, and this goes back to our material on criminalization theory. And if you remember that material, and if you've taken crim law, you might think of this as well. I mean, we're not ordinarily wanting to criminalize negligence, right? Ordinarily, negligence, mere negligence, is a matter for civil law, not for criminal law. So if I'm driving my car to work and, I take my eye off the road for a moment to adjust my radio and I plow into the car in front of me, I will confess I have some personal experience of this, right? Hit the car in front of me, have a fender bender, and cause some damage to the car and some alleged injury to the person. It's not a crime ordinarily. It's something that you'd face a civil lawsuit for, and insurance adjusts for it, and so on. So normally we do that. Now there are times when criminal law might have a criminal element of negligence. You've probably heard the term criminally negligent homicide. So there are cases where you're driving a car 90 miles an hour down the highway and you're looking, I don't have my phone in front of me, you're looking at your phone, you're texting someone, and you plow into the car in front of you and kill 3 people. It's quite possible that, yes, that's negligence, but maybe it rises to a level that could be criminally negligent homicide. So certain times, we might do that, but ordinarily we're criminalizing intent, or at least something like recklessness. So consider, again, if you've had criminal law, think about the distinction between murder and manslaughter, for example, right? Murder is the intentional killing of another human being with malice aforethought, right? So that mens rea is that malice aforethought. I've planned this. I meant to kill them, right? Manslaughter is the killing of another human being in the heat of passion, right? And different states might use different words, but the heat of passion. So I didn't plan this ahead of time, but I came home and found my partner in pari delicto with somebody else, and in a rage, I kill the person with whom they were so engaged. Not the same mens rea as murder, right? A different mens rea, something not quite recklessness, but something else. All right, so the court in Elonis does not resolve the question of recklessness. And we'll see that gets left and resolved in Counterman. So in Elonis, the court simply says there must be some conscious wrongdoing. So really just saying negligence is not enough. And it is not about what the receiver understands, right? It is about what the speaker intends, or at least potentially what the speaker does with recklessness short of actual intent. Okay, so there we have Elonis. We have, notice some discussion of whether in the concurrences whether the recklessness should have actually been addressed or not, and Justice Thomas concerned that the case really doesn't give any guidance. And the case is kind of a classic Supreme Court deciding the least it can possibly decide and then sending the case back down. All right, so Counterman now. We come to Counterman just this past term. And again, we have this question of a true threat statute. This time it is a state true threat statute. And the court holds that recklessness is, under a true threat statute, sufficient. Right? So the court now confirms that, yes, of course, actual intent is mens rea, but also recklessness. Now again, negligence, that's out under Elonis, but recklessness. And the court defines recklessness as the state show the defendant has consciously disregarded a substantial risk that his communication would be viewed as threatening violence. Notice that this standard of recklessness does turn the focus, at least to some extent, on the receiver. So yes, it is the speaker's mens rea, is the speaker intending, right, to actually threaten the person. They really may follow up on the threat to knife the person or whatever. Or is it reckless? And reckless means not just that the person on the other side would have reasonably thought it was a threat, but that the person making the communication disregards a substantial risk, right, that the other person would view it as threatening. Now you might ask yourself, okay, wait, how is recklessness really different from negligence under these standards? Great question. I mean, you may remember this from torts, and if you think about what's negligence versus what's recklessness, maybe for punitive damages or something like that, it's sort of like one of those metaphysical questions. You know, how many angels can dance on the head of a pin? It is very subtle. It doesn't revive negligence, but it does raise this subtlety. All right, so we see, factually, again, another sort of typical stalker scenario where this person is obsessed with, in this case, kind of just a local celebrity. Sometimes it's a major celebrity, right? And statements that kind of escalate, and some things that, really use some language that any ordinary person would probably be frightened of, certainly from a stranger. And we have the Colorado statute. And the only evidence, you might ask, by the way, how do you prove evidence of intent? How do you prove evidence of recklessness? Well, you might have an admission that's relatively rare. You might have the person actually act on the threat, and then you've got another crime, not just threats, right? Assault or battery or maybe murder. But very often it has to be circumstantial. So a jury is going to be presented with the circumstances and have to infer what the mental state is. All right, Justice Kagan's reasoning: yes, true threats are unprotected speech. Yes, mens rea matters. Yes, there is a policy reason for this, right? The First Amendment is one of our core constitutional values. We don't want to have crimes that unduly impinge on speech, and in her view, the mens rea requirement of recklessness strikes the right balance. All right. Now we have partial concurrence dissent. It's a little confusing procedurally, but right, there's a concurrence about what actually happens with remanding the case back below. But on the heart of it, Justice Sotomayor and Justice Gorsuch dissent. Say, well, first of all, the court shouldn't have reached the First Amendment issue. We didn't have to get to that. Kind of set that aside for our purposes right now, right? On the merits, they say, look, recklessness is not appropriate. And I find this really interesting, and one of the most interesting things about Counterman. When you look at the majority opinion, there is not really any discussion about whether, about the effect of the internet, about whether cyberspace, the internet, social media, changes the practical kind of balance that the court wants to draw. But the dissent very clearly brings out the notion that the internet makes things different. And in their view, the internet makes things different because we simply have to live with more unpleasant speech on the internet. Part of it is just a function of speaking mostly through text without the context of a person being in a room. Some of it is just there is a norm that's developed of heated debate, of sarcasm, of trolling, of memery, of all kinds of things, which in pre-internet era we wouldn't necessarily have tolerated, but which are not really the kind of threats, in the view of the dissent, that the law wants to get at. And as I mentioned, right, the dissent says, hey, there are groups outside the mainstream, and I'm pretty confident one of the things they have in mind is certain kinds of rap and trap and things like that. Have different norms about speech, and how will that relate to this standard of recklessness? Well, those kind of questions are ones that we're discussing this week, and you can see from the perspective of wanting to have a robust First Amendment and wanting to have an internet that is essentially open and essentially bottom up, and yet wanting to deal with this huge and damaging problem of stalking and harassment, it's really difficult to think of viable policy solutions. All right, I'll see you online this week.